Hello everyone, welcome to Jamaica 411. Thank you so much for stopping by, keeping me company as usual. If you're here with me for the first time, welcome. Please subscribe, share, like the video, and feel free to leave your comments. To my subscribers and regular viewers, welcome back. So nice to have you. And, I appreciate your company very greatly. Yes, I do. I must confess. So, you know the ropes. You want to go ahead and like the video from now on because I'm telling you, this should be the final part of the affidavit of Andrew Holness, which he filed in the Supreme Court asking for a judicial review of the Integrity Commission's report on him. And it is very interesting so far. The tug of war in the last one, I'm telling you. So also remember to share the video. It's very important that we share. I do my part too, Yes, man, I share it all about the place. Well, mostly on Facebook and in my WhatsApp groups with my comrades and so on. All right, so thank you in advance. And of course, I do appreciate it, as I said before. Well, let me get on with it because, we have a little way to go. We were at paragraph 50 and it is all the way up to 86 paragraphs. So we have 36 more to cover. So if you're coming across this video, please, there are 2 videos before. I would recommend that you check them out, the 2 that spoke about the affidavits. Watch the first one first, then the second, because you will get the full understanding of what is happening by the time you get to this video. So we had arrived at the part where there was a lot of to and fro between Holness's attorney, Gibson Henlin, and the director of investigation. They were telling him, you have no jurisdiction to be going outside of what was referred to you, which was Statutory Declaration 2021. And he insisted that he had the jurisdiction to ask about other years as well, and so on and so forth. All right, so let's now begin. We had left off at 49, so we're going to read 49 again. So at paragraph 49, it says, by letter dated the 27th of May, 2024, which is this year, the second respondent, Stevenson, enclosed further questions requesting for the first time income and expenditure statement for the period ending December 2021 and 2022. Information concerning the NFE bond issue, properties owned by Estate Bridge, and they exhibited a copy as evidence. At 50, there was some delay in responding to this request for various reasons, including the passage of Hurricane Beryl and my national duties associated therewith. Based on emails passing between my attorneys and the second respondent, Stevenson, I was told that by communication of the 24th of June 2024, the draft report was submitted to the Commission. Oh, as far back as June. So, let me read that again. I was told that by communication of the 24th of June 2024, the draft report was submitted to the Commission, and he was waiting on the responses to the letter of the 27th of May 2024. And what was contained in that letter again? The Director of Investigation first requested income and expenditure statement for the period ending December 2021 and 2022. They also wanted information concerning the NFE bond issue, and they wanted information about properties owned by Estate Bridge. The investigator said that he had sent the draft report to the Commission for consideration, obviously, and he was awaiting this information that in that letter of May 27, 2024. Let's continue. At paragraph 51, Holness stated, as I understood matters at that point, the second respondent, who is investigator Stevenson, was at the end or in the process of closing out his investigation. My attorneys, on my behalf, had repeatedly objected to the irregularity in the investigation on the basis, but not limited to, that I was not provided with the sum that represented the assets that were disproportionate to my earnings, and I had complied with filing and declaration from which it was determined that the 4.4 million was an unexplained change. You say you send the draft report to the commissioners for consideration. And look, from when may I ask you what it is that you're saying that is unexplained. Up to now, give me the figure, But you send the report to the commissioners for them to consider. And this is what the attorney was complaining about, right? Let's continue at 52. I was advised by my attorneys at law and do verily believe that the request for income and expenditure statement at this stage of the investigation was irregular, unfair, and unreasonable, especially when it is considered that they had, on my behalf, consistently objected to the substance of the investigation as being a departure from what is required by Section 14.5 of the Corruption Prevention Act. They objected on the basis that it was not established that I owned assets disproportionate to my income, whereby I would then be required to provide an explanation. At 53, he went on to say that accordingly, on my behalf, by letter dated the 16th of July, remember the last one was June, right? 16th of July, 2024, my attorneys enclosed the response to some of the questions subject to my objections. The objections incorporated all previous objections, summarized as follows. A. The 22 declaration has not been examined by the Director of Complaints, and that it is improper and not in keeping with the Integrity Commission Act for the Director of Investigation to be examining the 2022 declaration. Yes, it must first, when the declaration is going, it must first be examined. And if there's an issue, the Director of Complaints and Information, or Information and Complaints, is supposed to call or communicate with the declarant what the issues are for clarity. If they fail to clarify within the time period that is given, then the matter now should be escalated and sent to the commissioners, who will then now send it to the Director of Investigation for him to carry out his investigations. That is a process. So this declaration 2022, Beresford, who is the Director of Information and Complaints, said he has not, or had not at the time, started to examine that declaration because he's waiting for the investigator to come back to him with having done some investigation that was referred to him about the 1.9, well, it was actually 4.4 million that he was supposed to have been investigating, that appears to have been disproportionate to Holness's income, right? And therefore, the Beresford is waiting for that to start the examination of 2022. And here it is, the investigator is investigating something that has not even been touched by the man who has the responsibility under the law to examine and refer if need be. Do you understand what I'm saying? This is more than irregular. This is strange beyond belief. It is strange beyond belief. First of all, how the hell did he get hold of the 2022 declaration? It must have come from Beresford. He must have asked Beresford for it, and Beresford sent it to him. Maybe he didn't even know why he wanted it. And there he was conducting a big elaborate investigation when the statutory declaration of 2022 was not even examined to see if anything in there is accurate or additional information is needed. I mean, this is an abuse of power. And then him have it over them head, because if they don't respond, that alone is a criminal offense. Or I think it's a criminal offense. It certainly is an offense under the law. if they don't respond, he could be charged just like that for illicit enrichment by refusing to answer the questions, right, on a timely basis, or neglecting to answer the questions on a timely basis. So they were duty bound to respond, even though they were objecting. You understand that, right? They could not refuse not to respond. He would have been in trouble. Anyway, so that's the situation. I mean, this is so incredible. Hey, them judge face when I'm ready, I'd love to hear what the judge have to say about this, especially when it comes to authority and people abusing them authority. Anyway, let me continue. Holness' second objection at B says, lack of due process or procedural impropriety. The principles of due process were and have not been observed, including non-compliance with the legal requirements, procedural safeguards, and constitutional guarantees. This man was just out there running amok, the investigator. Holness' third objection at C said, timely investigation or delay. The investigation was not conducted promptly, such that I have suffered injustice and ignominy, failing to observe the threshold requirements or coercive methods. I was investigated without regard for the conditions precedent to Section 14.5 of the Corruption Prevention Act on the pain of prosecution. At D, his objection was, I will not provide income and expenditure statement because it is not required as explained above in this affidavit. And he exhibited that communication as evidence. Section 54, the objections, particularly as it related to the unlawful or irregular exercise of power and discretion by the second respondent, Stevenson, is confirmed by responses received from the first respondent, who is Beresford. It became clear that the first respondent abdicated his independence, fairness, and duty to examine the declarations for 2022 and 2023 to the second respondent. Now, you want to remember that this is in July 2024. So the 2023 statutory declaration would have been submitted by March 31 of 2024. All right. So they are complaining that Beresford, who is the one who is supposed to examine the declaration, appeared to them that he had basically handed over that responsibility to the investigator. He apparently did not examine those declarations, and he handed them over to the investigator for his investigation. What can go so? That don't make no sense. That must be totally against the law. Anyway, let me continue. It goes on to say, similarly, the second respondent, who is Stevenson, was unmindful of the objections to his abuse of his authority and breach of statutory duty. At 55, he said, the first respondent, Beresford, was specifically asked whether he examined the 2022 declaration on the 12th of February 2024. He advised that he had not done so and was waiting on the outcome of the investigation of the 2021 declaration before doing so. And this occurred in February of 2024. He went on to say, this was almost 1 year after the declaration was properly filed as required by law. This prejudiced my interest and threatened to cause further prejudice, as by this time the public was questioning the delay, fueled in part by political party partisanship. The delay in examining my 2021, 2022, and 2023 declarations has created a cloud over me that is personal to me and affects my interests significantly. And he exhibited the email thread as evidence. And that from the 12th of February 2023 to the 10th of September 2024. There are a series of to and fro apparently, and he exhibited those emails as evidence. At paragraph 56, Holness stated that given the detailed nature of the objections in my letter of 16th July 2024, which I also incorporated into my responses, I expected that a response would be given or a hearing convened. Instead, based on the report of the 30th of August 2024, that's the one that was tabled, which is the subject matter of this claim, the report was sent to the Director of Corruption Prosecution on the 19th of July 2024. The only matters referred were in relation to 4 accounts and in relation to the offense of making a false declaration, and he exhibited a copy of the report. It says here, a copy of the report of the Director of Corruption Prosecution dated the 2nd of September 2024 is being shown to me and marked as AH29. So they exhibited the report from the Director of Corruption Prosecution as evidence. At 57, he said, I am now seeing from the reports, including the report from the Director of Corruption Prosecution, and letters that were submitted to Parliament, that the report dated the 30th of August 2024 was submitted to the Director of Corruption Prosecution on the 19th of July 2024. Among other things, it fortified my belief that the report was complete as at the 24th of June 2024, and at best by the 19th of July 2024, as it is my understanding from the Integrity Commission Act that she gets the file for consideration once the completed report is submitted to the third respondent, the commissioners, with a recommendation of anything that is to be referred to her. In addition, the only matters submitted were done by the second respondent, Stevenson, and not the third respondent. Oh, what did the concierge tell me, say? In addition, the only matters submitted were done by the second respondent and not the commissioners, the investigator. I don't get that. Let me go and read. In addition, the Director of Corruption Prosecution reported that she did not find a basis for prosecution in relation to the 4 accounts referred, that it came to my attention in the public domain that the third respondent, the commissioners, submitted its report and the report of the Director of Corruption Prosecution for tabling. The reports were enclosed in letter dated the 5th September 2024, signed by the Executive Director on behalf of the Commission. The special report and the letters were signed on behalf of the Commission by the Executive Director. The reports were tabled in Parliament on the 17th of September 2024. At 59, he said, I was appalled when I read it in light of the objections that were being made on my behalf. I have been informed by my attorneys at law and do verily believe that A, there was no finding of reasonable suspicion of corruption or an offense under the Integrity Commission Act in respect of any matters outside of the 4 accounts for which the Director of Corruption Prosecution ruled that there was no case to be answered, and based on the report, none existed at the time that the matter was referred to the second respondent. It was a fishing expedition into the business or affairs of the applicants. Now, you remember I said that when they had sent to the titles office and to the land title, what they call National Land Agency, they didn't, and the company's office, they were on a fishing expedition. They didn't have the name of or title number or name of any companies asking them to check these out and give us information. They asked them, look up the name of so and all these persons who were associated with the companies and tell me if you see where them own any properties, because it can be done. It's computerized. They did it for the companies. and they found the third company. It's the charity, right? And they also found that certain of the persons who were being looked into, they had properties as well, and two did not. So, Holness, these lawyers are saying that this was a fishing expedition. Let me continue. B. In relation to the 2021 declaration, the second respondent in his report stated at least 3 times that there was no unexplained growth in my net worth. See paragraphs 5.8.18, 5.8.20, and 6.21 as examples. There is a negative net worth of 10 million in that case. True. Remember we saw that? 10 million in 2021, 5 million in 2022. Right. For 2022, which is still awaiting examination by the first respondent, the law says he must examine the Prime Minister one and the leader of the opposition, them the two that you examine and certify, unless them have an issue. And all now them not look upon it yet. That can only be, but how can that be, by the way? It can only be because there was a threat that they are not going to certify his declarations unless the FID look into the matter. You recall that? That was what they sent to Parliament. They wanted Parliament to refer, imagine that, they want the Parliament to refer the report to the FID. When they had the opportunity to consult with the FID the whole time, right? And the consequence of that is further delaying the man's declaration. Something not right here, so something not right here, so at all. So let me continue and I'll read it again. For 2022, which is still awaiting examination by the first respondent, Beresford, there is or are no statement or statements of the value by which my assets are disproportionate to my lawful income. The report states that there is a negative net worth of 5.3 million. Remember that? Yes. Indeed, there is a statement that the sum of 1.9 million was found, which I am required to explain. There are 3 reasons why this is unreasonable or irrational by itself. 1. The sum was arrived at by unlawfully combining the resources of the first and second applicants, his resources and Imperium. The sum was never put to me for explanation, and the first time that I saw it was in the report of the 30th of August 2024 after a tabling of Parliament. Can you imagine? The sum of 1.93 million cannot properly be regarded as disproportionate to trigger an explanation in any event. It is therefore a breach of duty or abuse of power and or discretion when the second respondent, Stevenson, stated that he was unable to come to a conclusion or complete the report on the basis that I refused to supply information to enable him to assess the sum of $1.9 million. He arrived at the sum by performing a mathematical exercise which included my income from all lawful sources, and he did not ask for an explanation of that sum, which is what is required. At F, he said, this figure of 1.9 million was never provided to me for explanation as required by an investigation for illicit enrichment. It is a figure arrived at only because he acted in excess of his authority and unlawfully when he pierced the corporate veil of the second applicant. I do believe I heard Emily Shields explaining what that corporate veil means. So you can go look her up on YouTube and listen to what she had to say. All right, she's a lawyer, so she should know these things better than I. I'm no lawyer. I only use my common sense, and so do you. At G, he said, the finding and conclusion and decision that the 1.9 million is disproportionate to the combined earnings of the first and second applicants, Holness and Imperium, is unreasonable and irrational. I have been reliably informed by my attorneys at law and do verily believe that disproportionate does not mean more than. It means too large or significant. By my rudimentary calculations, this sum is less than 10% of my lawful earnings from all sources. Notwithstanding the Director of Investigations finding that the offense of illicit enrichment was not made out against me in relation to my 2021 declarations, the Commission has and continues to fail to certify the 2021 declaration. Notwithstanding the Director of Investigations' failure to find that the offense of illicit enrichment was made out in relation to me in relation to my 2022 declaration, the first and third respondents, the first would be Beresford and the third would be the commissioners, have failed to certify my 2022 declaration. The third respondents would be the commissioners, has also attempted to refer my 2022 statutory declarations to the Financial Investigations Division and or to delay the certification of the 2022 pending investigation by the FID, which is improper in all the circumstances. They knew that the request for income and expenditure pursuant to Section 47 of the Integrity Commission Act was a ploy, that's a serious language, to continue the illegal and unfair investigation, and knew that if they communicated to the public that I refused to submit information, the public sentiment would be stirred up against me. Lord have mercy. When them judges at the Supreme Court hear about that. Anyway, let me continue. Breach of natural justice and procedural fairness. So this is now the topic at 60. I am advised by my attorneys at law and do verily believe that the investigation was procedurally unfair and pursued for an improper purpose from the outset, insofar as the respondents, all three of them, failed to provide me with the sum or wealth that was disproportionate to my lawful earnings and reserved to themselves a right to ask any question and questions that were not relevant to the required explanation under Section 14.5 of the Corruption Prevention Act. It is now clear from the report that the respondents withheld information from me, as I explained above, as they knew that the sum that they were concerned about was $4.4 million. They knew in the course of their investigation that this sum was no longer a concern for 2021, as it is disclosed now in the report of the 30th of August, 2024, that for the period ending the 31st of December 2021, I landed at a negative net worth as explained above and in the report. At 61, he said, after embarking on the question and answer process for over a year, I am advised by my attorneys at law and do verily believe that procedural fairness required that the second and third respondents, the investigator and Mr. Beresford, provide me with adequate notice of their proposed decisions at every step of the investigation, or at best, prior to making recommendations that are adverse to my interests, and to provide me with an opportunity to respond. The second and third respondents, that's the investigator and the commissioners, made adverse findings against me without giving me an opportunity to respond based on statements from undisclosed witnesses whose statements were not put to me in the making of the adverse findings, conclusions, and or recommendations. The second to fourth applicants, the companies, were treated in the same way as they were not afforded fairness or specific hearings on their behalf. Really amateurish thing this I'm describing of, my peeps. The findings of fact and conclusions about the bond is also unfair. I responded to all questions asked of me, and I explained what the error was. No further question was asked of me, and I am concerned that adverse findings were made in relation to it, and I was not given an opportunity to respond or the basis of those findings. At 63, he said, the investigation was procedurally unfair from the outset insofar as the respondents represented that they were proceeding under Section 14.5 of the Corruption Prevention Act, but instead proceeded to inquire into the business and affairs of the applicants without reference to the procedure for investigating illicit enrichment, or telling me exactly what I was required to explain, or the new matter that was discovered. Now, I think at this point I probably should caution everyone to remember, even though I said initially that this was Holness's side of the story, please remember that this is only his version of the events. We are yet to hear from the attorneys for the commission as to what their version of events are. So this sounds very bad so far, but who knows, maybe when they come with their version of events, it may be quite a different story. But let us continue with what we have before us. At paragraph 64, Holness said, the second respondent, who is Stevenson, proceeded unfairly by broadening the scope of the investigation from what was communicated to me by notice of the 18th of August 2024, resulting in a moving target such that he demanded to investigate 2022 and 2023 declarations, such that the investigation turned out to be no more than a fishing expedition, and in respect of which he made findings and decisions adverse to my interests. In this respect, apart from the communications with my attorneys at law, there is also his terms of reference at page 28 of the report of the 30th of August 2024. The decision, findings, and conclusions relating to the combined net worth of 1.9 million is unreasonable and irrational because the second and the third respondent, that's the investigator and the commissioners, fail to have regard to the finding in the report that my net worth for 2021 and 2022 was negative and that there was no unexplained growth in my net worth. No, but they were also investigating the companies, and that's where they said that the problem was, or so they claim. And that was what the commissioner sent him to look into, the companies, not your affairs. Anyway, at 66, he said, I am advised by my attorneys at law and do verily believe that the second and third respondents acted ultra vires the Integrity Commission Act illegally or in a procedurally unfair manner in lifting the corporate veil, having not found fraud or reasonable suspicion of corruption or an offense under the Integrity Commission Act in respect of any matters outside of the 4 accounts for which the Director of Corruption Prosecution ruled that there was no case to answer, or applying to the court to lift the corporate veil. It was also unfair in circumstances where the finding in the report at paragraph 5.8.18 is that there was no unexplained growth in my assets and liability relative to my income in 2021 and 2022. My total net worth for 2021 was negative 10.4 million and negative 5.3 million was observed for 2022. At 67, he said, the second and third respondents, that's the investigator and the commission, have acted in bad faith and unfairly in recommending in the report to the third respondent and the third respondent submitting it for tabling in Parliament. This is because at the time when this finding was made, I had not provided the income and expenditure statement which the second respondent, Stevenson, claimed in paragraph 6.1.2 hindered his attempt to fully resolve unexplained sum of $1.9 million. At no time was a forensic report or the contents of it put to me for comment, given the seriousness of the matter and given that findings of fact and conclusions were arrived at in relation to it. I was reliably informed by my attorneys at law and do verily believe that I was entitled to know if there was any exculpatory evidence in it, especially because the 30th of August 2024 report was completed and submitted to Parliament and stated that there was heavy reliance on it. You remember we had said that? How come they did not submit the forensic experts report with the report that they sent to Parliament? That was odd, wasn't it? I am reliably informed by my attorneys at law and do verily believe that the referrals to the FID and Income Tax Department are improper referrals having regard to the scheme of the Integrity Commission Act and the report, and that there is no bar to the certification of my declarations. Ultra-vires, illegality, and abuse of discretion. At 70, Holness said, I am advised by my attorneys at law and do verily believe that the second respondent, Stevenson, acted ultra vires, the Integrity Commission Act, and or illegally, having completed his report and having not made any statement of reasonable suspicion of corruption or an offense under the Integrity Commission Act in respect of any matters outside of the 4 accounts for which the Director of Corruption Prosecution ruled that there was no case to be answered, in failing to recommend to the third respondent, the Commission, that I be publicly exonerated. I am advised by my attorneys at law and do verily believe that the reference of the report and findings to the FID and TAJ represents an unlawful delegation and or abdication of the second and third respondents and or the Director of Corruption Prosecution statutory responsibility. It was also straying into areas that were not referred and not the subject of the Integrity Commission Act for report to Parliament. You hear that? Whatever it is that tax breach there may have been, they are saying that that was improperly referred because the Integrity Commission Act does not require that it should be reported to Parliament. So that should not have been part of it, is basically what it seems to be saying here. I believe that the tabling of the report was intended to embarrass and cause harm to me, and as such was made for an improper purpose and in bad faith to prejudice and harm me, given that the entire scheme of the Integrity Commission Act is to ensure confidentiality and secure fairness to those who are being legitimately investigated. In addition to the report, the third respondent issued a special report dated the 5th September 2024. The special report inter alia stated, the referenced report of investigation was formally submitted to the Parliament today, September 5, 2024. The Integrity Commission is hereby urging the Parliament to support this referral of its Director of Investigation, as there can be no finality in the matter until the FID has completed its work. You remember me tell you, the Commission was trying its hand at a little blackmail. Yes, that not sound like blackmail to you. Look, I am not going to certify. They know he's anxious to get his certification done, because the lawyers, even though they were objecting, they were still cooperating. So they knew that he wanted to get the certification done quickly. So they are saying, look, it'll go to the FID, don't go to the FID without certifying. Sound like blackmail to me? Don't know what it sounds like to you. What do you think? Leave your comments in the comment section. Let me continue. Please, let me hear what you think about it. The Commission reminds Parliament that in keeping with the provisions of the Integrity Commission Act, there can be no certification of a statutory declaration until the Commissioner's Director of Information and Complaints is satisfied that the statutory declaration has been duly completed. Once he is so satisfied, he will inform the Commission. At 74, he said, I am advised by my attorneys and law and do verily believe that the third respondent's statement, this is the Commission itself now, and I'm quoting, there can be no finality in the matter until the FID has completed its work, end of quote, is contrary to the statutory regime, as the responsibility to complete any work under the Integrity Commission Act is placed on the second and third respondents, that's the investigator and the Commission itself, and no other entity. Further, the third respondents, the Commission, statement that there can be no certification of a statutory declaration until the Commissioner's Director of Information and Complaints is satisfied that the statutory declaration has been duly completed, is made based upon an unlawful foundation in that it presumes that the Director of Information and Complaints satisfaction is to be generated by the work of others, in this case, the FID. There is no statutory basis for this position. In any event, this statement shows that the third respondent, the Commission, has encroached on the proper performance of the duties imposed on the first respondent, Beresford, by the Integrity Commission Act. It also shows that the first respondent, Beresford, has abdicated his duties to the third respondent, which is the Commission. In other words, by their actions, the second and third respondents, that's Stevenson and the Commission, have usurped or encroached on the statutory role of the first respondent, Beresford. The first respondent refused to examine the statutory declarations of 2022 and 2023 or to certify the 2021 declaration. He has ceded his statutory role to the first and second respondents insofar as there has been no examination by him of my declarations for 2022 and 2023 and no certification of the 2021 declaration. Between the 6th and 10th September 2024, the first respondent, Beresford, was asked whether he had examined the 2022 and 2023 and or is able to examine and or certify the 2021, 2022 and 2023. He advised on the 9th and 10th September 2024, that's just a few days later, that having spoken to the second respondent, the investigator, he is unable to comment any further. No further light was shed on the matter. He has therefore refused to perform his statutory duty. I hereby refer to Exhibit AH 28. Accordingly, the findings, conclusions, and or recommendations made in relation to me by the second respondent, the investigator, which are contained in an investigation report dated the 30th of August 2023, actually that should be the 30th of August 2024, were made in breach of the principles of natural justice and procedural fairness. The process utilized by the second and third respondents, Stevenson and the Commission, to conduct and making findings of fact, law, and recommendations in relation to the applicants in the report is unreasonable and irrational. And if the court finds accordingly, it serves them right for not using an attorney at law as they went along. At 78, Holness said, I have a legitimate or reasonable expectation that the second and third respondents, the investigator and the Commission, would have observed the principles of natural justice, procedural fairness, comply with the Integrity Commission Act and any other relevant legislation, and considered relevant considerations in conducting its investigation, which led to its findings, conclusions, and/or recommendations made in relation to me, which are contained in an investigation report dated the 30th of August, supposed to be 2024, and the special report of the 5th September 2024, that should read. At 79, he said, the respondents have failed to observe the principles of natural justice and procedural fairness in dealing with my declarations from 2021, 2022, and 2023. A. Reopening for investigation declarations that were already certified without first notifying me. B. Insisting on proceeding in the face of objection. At 80, he said, this conduct has also breached the principles of legitimate expectation on the Integrity Commission Act, which requires that respondents to act impartially, fairly, and independently. That I have been reliably informed by my attorneys at law and do verily believe that the entire report is impeachable on the basis set out in the notice of application for court orders, that my constitutional rights as set out in the application have been breached. The applicants have a sufficient interest in the matter as each of them is directly affected by the respondent's action, which is the basis on which the application is being made. This application is made promptly. There is no other alternative form of redress available to me. In any event, judicial review is more convenient, suitable, effective, efficient, and expedient. In the premises, I humbly pray that this honorable court will grant the reliefs prayed for in this matter. I don't have the orders for you, but I will get them. I hear Cliff Hughes must have read them out, so I'll try and get it from Cliff Hughes. So that's it. This is the conclusion of the affidavit filed by Andrew Holness in support of court orders. He requested of the Supreme Court a judicial review into the statutory declaration because, as he said, at paragraph 85, there is no other redress available to him. He can't go anywhere. He has to go to the court. And the reason why he's asking for a judicial review is because it is convenient, suitable, effective, efficient, and expedient. In other words, it's quick and fast. All right? So that's it for me. I hope you enjoyed the reading of the affidavit. And as soon as we have the response or the reply by the Integrity Commission's attorneys, then I will come and read that for you and see if we can make head and tail of it as well. Anyway, that's it for me today. Thank you so much for joining me. I hope you share. You've already given it a thumbs up. If you haven't, please do. And leave your comments, subscribe, and of course, until next time, you take very good care of yourselves and walk good.